setting up a new business, starting a new enterprise does not have to be complicated, but it needs to be smart. The key in structuring the entity in which you will do business is to win your lawsuit before you file it, or before it is filed against you. Whether you're having a business individually by yourself or with partners will affect the complexity and the terms of your agreement. Being a sole proprietor has been the American way for many, many years. And it's built our country, and it's a wonderful thing. It's just legally stupid. What you need to do is take the benefits and protections of a legal entity in the event of things you have no control of, like a 6-year recession, cancer, death, divorce, things that as a sole proprietor you could have extreme issues and a lot of attorney's fees that can be avoided if you are smart when you commence the business. Whether you choose a Texas General Partnership, a limited liability partnership, a limited liability company, a C Corp, a S Corp, depends on the facts in your life, what you're going to do and what's the best result. As an individual, at a minimum, it will give you liability protection. It will isolate the assets and accounts in your corporation or your limited liability company, so if it fails, you don't have personal liability, you don't get to spend your kids' college funds on bad debts because the economy's gone. A lot more significant, though, is if there's a partner, or 2 partners, or 3 partners. And there are a number of ways to maintain control of your company and still have others involved in it. But they all are derivative of doing the agreement before you start the business. Set up the terms. Let's just assume it's a limited liability company. Make sure that the major items of the company. Protect yourself from the death of one of the members and the claims of the estate of the surviving spouse. Protect yourself from a lazy member who won't work. Protect yourself from divorce. In any of the entities that are recognized by the state of Texas, you have the right to put the terms. Who's going to run the company? How will the profits be distributed? If positions become intolerable among one or more of the members, how are you going to get that member out without going broke? Buy-sell agreements are very useful and very, very effective for death, where the spouse gets a check from the insurance company and you get the rest of the company. Or from a divorce, where the spouse will get her interest, but she must sell it at a fixed price to the company. In other words, you can't keep her estate from having its legitimate interest in your business. But you can keep her nose out of the business while you pay her interest.
NACAW Law Firm, may I help you?